meeting Monday, August 28, 2017. I hereby declare this meeting of the Howell Township Zoning Board to be open. Adequate notice having been given pursuant to the New Jersey Open Public Meeting Act in the following manner. First, on January 10, 2017, a copy of said notice was mailed to the Star Ledger and the Tri-Town News. Second, on January 10, 2017, a copy of said notice was hand-delivered to the clerk of the Township of Howell. Third, on January 10, 2017, said notice was posted in the office of the Zoning Board and on the bulletin board in the Howell Township Municipal Building, 4567 Route 9, Howell Township, New Jersey. In accordance with the Fire Prevention Code and your safety, please be advised that this facility is designed with 2 emergency exits, which are on your right at the front and rear of the meeting room. Furthermore, smoking is not permitted in the municipal building. Please take note that this meeting is being videotaped for possible future broadcast on Howell Township TV 77.
Thank you, Eileen. Can we have a roll call, please?
Yes, you may. Mr. Armada.
Present.
Mr. Cordelicchio.
Present.
Mr. Mertens.
Here.
Mr. O'Donnell.
Here.
Mr. Posh.
Here.
Mr. San Clemente has been excused. Mr. Turk.
Here.
Mr. Bloom.
Here.
Chairman Nansen.
Here.
You have a quorum.
Thank you. Can we all please stand for the Pledge of Allegiance? And we're going to take a moment of silence for those in our southern states, for what they're going through right after the Pledge of Allegiance. Pledge
Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Mr. Kuchera, you mind swearing in the professionals, please?
You swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Approval of minutes,
We have no minutes this evening.
vouchers,
No vouchers.
correspondence.
I don't really have correspondence, but I was speaking to Mr. Gazarowski today. He is the attorney for Stavola Leasing, which is on our agenda. And there was a problem with their notice, so they have to be renoticed, and they will be carried or renoticed for September 11th, 2017. Do you have to?
September 11th.
Yes, so they will not be heard this evening.
And just to
Okay.
be clear, they are going to renotice, so we're not carrying them without further notice. They have to renotice property owners.
Okay. Is there anyone in the audience for case number BA 17-13, Stavola Leasing? This case will be carried to September 11th with further notice.
And that's all I have. Everything else was emailed to the members.
Okay. Resolutions, case number BA 08-14, Henry Potavarchani, resolution granting a 2-year extension of time. Eligible voters, Armada, O'Donnell, Posh, and Nansen. Do I have a motion?
Motion to approve.
Motion by Mr. O'Donnell,
I'll second it.
seconded by Mr. Armada. Can we have a roll call, please?
Mr. Armada,
Yes.
Mr. O'Donnell,
Yes.
Mr. Posh,
Yes.
and Chairman Nansen.
Yes.
Resolutions memorialized.
Thank you. Okay, application before the board, case number BA 17-05, Mark Parisi, appeal of zoning officer's decision. Application of Mark Parisi is applicant, Mark and Sandra Parisi as owners seeking an appeal of zoning officer's decision regarding a noise complaint from the applicant with regards to the Escape movie theater on the applicant's premises known as Block 25, Lot 74.09, 2 Castle Court. This appeal was partially heard on May 8, 2017, when it was carried to July 10, 2017, with no further notice. On July 10, 2017. This application was carried to August 14th, 2017, with no further notice. On August 14th, 2017, it was carried to August 28th, 2017, with no further notice. Expiration date, September 30th, 2017. Eligible voters, Armada, Carlicchio, Mertens, O'Donnell, Posh, San Clemente, Turk, Bloom, and Nance.
Thank you,
Mr.
Mr. Chairman. For the record, my name is Gordon Gemma. I represent the applicants, Mark and Sandra Parisi. And you're correct as to the past dates that took place. If the board would recollect, in the May hearing, we were asked to come back and have time to put together a report. We were asked to have a report in front of the board with sufficient time for the board, professionals, as well as for Mr. Sonnenblick and his clients to review the report. It wasn't done in time for the meeting of the beginning of July. The report and the other documents, including the transcripts of the original hearing, were in fact provided to this board by my letter of July 14th. On my letter of July 14th, we provided the report, we provided transcripts of the prior hearing, we provided emails from Mr. Parisi, and we also provided a court case, an appellate division decision that in fact upheld the standards that were utilized for the ordinance, which are similar to the ordinance that Howell has. And so tonight, we were asked at the last time to make sure that we had an objectified standard by which this board could render a decision whether in fact the actions of the zoning official were appropriate or not appropriate in terms of enforcing a noise ordinance. And that's what we did. We provided the time for Mr. Sonnenblick and his clients to look at it. We provided time for the board and their experts to look at the report. And so what I'd like to do tonight is two things. The first thing I'd like to do is just some housekeeping, and just we left off with the last exhibit as A15. I'd like to mark my letter of July 14th, 2017 as A16. I'd like to look at the transcript of April 13th, 2015 as A17. I'd like to mark the transcript of April 27th, 2015 as A18.
Excuse me, Mr. Gemma. They're already marked as A11
Okay,
and
good.
12.
Good, thank you very much.
You're welcome.
11 and 12 makes life easier. I'd like to report from Eric Zwirling, who's here tonight and will testify, as A17 then.
Is that the noise consultancy?
That is the noise consultancy.
That's also on there as A13?
You are way ahead of me, once again.
Sorry.
No. How about the State v. Clarksburg?
That's A14?
You are, why bother? And the emails as A15, you have them there? Thank you very much, and I appreciate that. Thank you, Earl.
Just, Mr. Gemma, before you move forward with that, I just wanted to give maybe even a couple steps back overview of where we were and how we got there to here. The matter emanates, I think as Mr. Gemma alluded to the board's approval in the matter captioned as AAM Mill LLC, Block 25, Lot 54.01. It was a resolution dated June 8th, 2015 for the movie theater, and specifically it concerns representations that were made on the record, which are enumerated in paragraph 11 on page 9 of the resolution concerning the noise that would emanate from the theater. Mr. Parisi has felt that the noise which comes from the theater is in violation or in excess of that which was represented in paragraph 11. It's well-settled case law that when representations are made on the record by an applicant, whether they are captured specifically in the conditions or whether they are more generally referenced in the record and in the resolution, they're still bound by those representations. So Mr. Parisi filed a complaint with the zoning department concerning violation of the ordinance. My understanding is initially there was a summons that was issued which was later rescinded, and then there was a subsequent complaint to the zoning department regarding noise violations. The zoning department doesn't possess the apparatus to actually take the noise readings themselves. The county, which does have that apparatus, came in and performed tests where they found 0 decibel levels on the Parisi property. Based upon that, the zoning officer determined that there was nothing no violation of the resolution. He specifically referenced the resolution in his letter dated February 28th, 2017. A timely appeal was made within 20 days of the issuance of that letter pursuant to Section 78 of the Municipal Land Use Law, and that's what this application is. The sole purpose of this application is to determine whether the zoning officer or the land use director, Matthew Howard, properly enforced the terms of the resolution. So that's the narrow scope that we're looking at this from. Was the resolution violated, or was it not violated? So that's what we're here to do. And Mr. Gemma is correct. At the conclusion of the last hearing, he did ask for the opportunity to present an expert report, which would, amongst other things, try to quantify what the method was to measure the noise coming off the property. So that's where we are now, and I think, Mr. Gemma, we're up to the point where you'd put your expert up?
Yes, what I'd like to do before I put up my expert is just one thing. I'd like to authenticate the emails. I just like to ask Mr. Parisi to come up here just to state for the record the emails are actual, the unaltered communications between himself and the applicant, and just so I can get that done with relatively quickly, if you don't mind, so that way we can put on the record that they are in fact representations of what they're made to be.
Okay, Mr. Gemma, Mr. Sonneblick, do you have someone here to authenticate those emails?
No. I am not even going to say that I disagree that those emails were sent, but I object to
Mr.
them.
Sonneblick, can you just enter your appearance first and who your
Gerald
clients are?
Sonneblick, attorney for the respondent, I guess, in this particular case.
No, it's just the property owner.
The property owner and the movie theater.
Okay, and can you give us the corporate entities?
Well, we have, the property owner is, everybody knows, AAM Mill LLC. That's how this board has always dealt with the property owner. And the movie folks are Express Theaters, and I don't have the Escape Movie Theater is really what we'll call it for the purposes of this application. At this point, I could always provide you with the corporate information at another time.
Okay. So, Mr. Gemma, so Mr. Sonneblick's clients aren't here, so he doesn't have an ability to really object or not. I guess my question is not towards the authentication, but to the relevance of the emails.
As you know, the strict rules of evidence don't apply.
Yes.
It's our proposition that these are admissions against interest. And the relevance is that, and Mr. Parisi will authenticate that, in fact, these are actual emails, and the board could make his own decision, but they are emails from the theater operator who, in fact, acknowledged they went on Mr. Parisi's property, and they acknowledged there was noise. And they also went one step further. They also said they would do something, that they were going to obtain equipment, and they were going to try to, quote, fix the issue. And to the best of Mr. Parisi's knowledge and belief, nothing was ever done. And as admissions against interest, they can then be utilized as hearsay evidence because they're an admission by the applicant that, in fact, they heard something. And so the relevance is clear. It's not just Mr. Parisi saying he's hearing things, the applicant heard something. And that's why they're relevant, that's why they're admissions against interest, and that's why they should be authenticated and then entered onto the record pursuant to the exception to the hearsay rule.
I would enter my objection. I don't think they're relevant. There has not been an issue, at least to this point, this has been going on for quite some time, that there may be some sound that escapes the escape theater. The question really is there a violation of any ordinance, and not what the two parties speak to. If you want to talk about settlement purposes for the board's acknowledgement Thursday night after having gotten their noise expert's report.
No, we're not.
All right.
Your settlement negotiations are
not relevant.
it's improper
Well,
to.
the emails are referring to possibly working out a settlement.
Is that true, Mr. Gemma?
No, I would suggest this. I would ask Mr. Parisi to authenticate them. The board was provided copies of these emails, the package, on July 14th. They've been on the record for more than 10 days. The board can read the emails and make their own determination whether in fact they were for settlement or whether in fact, as we indicate, they are an admission against interest
Mr.
by the
Chairman,
applicant.
Can I recommend this, or suggest this, rather?
Please.
Why don't we swear in your professional, and while he's giving his testimony, I can re-review the emails, and we can return to that issue after your expert's done.
Fine, but again, I just note for the record that they are A15, they've been on the record, they've been
That's fine.
for
That's
at least
fine.
10 days, and they're part of the overall package by the applicant.
Okay.
I'll gladly go to Mr. Zwirling
Okay.
while you review them, Ron, and then you can make a determination. But I would ask for a ruling on the record tonight.
I think we're going to dispose of all issues tonight.
I'm sure you will. If I could, Mark, Eric.
Hey, if I could just swear you in, sir? Sir?
I'm sorry, yes, stand please and be sworn.
Do you swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state and spell your name, and make sure you get close to the mic so we pick you up.
My name is Eric Zwirling, Z as in zebra, Werling.
Thank you. Mr. Zwirling, can you just give your address, please, for the record?
Oh, I'm sorry. 309 Van Ness Road in Flemington, New Jersey.
And if you could, Mr. Zwirling, just describe your qualifications and experience in the field of a noise expert.
For 27 years, I've been the director of the Rutgers Noise Technical Assistance Center. In that capacity, I've trained every noise enforcement officer in the state of New Jersey. I do that across the entirety of the United States, from Anchorage, Alaska, to Fort Lauderdale, Florida, and internationally from Canada to Barbados. In my capacity at Rutgers University, I've also done a number of research projects, including for the US EPA, a community noise assessment, $300,000 study, train noise in Teaneck, New Jersey. I've assisted in the drafting and the redrafting of the state code, the model noise ordinance. These are all in my capacity at Rutgers. I provide technical assistance to communities, governmental agencies, to industry, to residents. In my capacity at the Noise Consultancy LLC, in which I appear today, I've written noise ordinances for jurisdictions, again, across the United States, from Juneau, Alaska to Fort Lauderdale. Both adopted codes I had written in the same week, just to show the breadth of what I've done. I've consulted for government agencies ranging from the New York City Law Department, where I appeared as for them as an expert witness in federal court in the Southern District of New York, through to the Philadelphia Law Department, New York State Attorney General's office, et cetera.
Okay, so have you ever been accepted by a board in New Jersey as a noise expert?
Yes, throughout New Jersey, and in fact, I've also been hired by a number of boards as their acoustical experts. Some I'm on an annual contract, others they hire me on an ad hoc
Can you
basis.
give us an example of some of those boards?
Branchburg, New Jersey, Reddington Township, New Jersey.
The planning board or zoning board, just to be clear, for the town council?
I think it's for the board, zoning board and planning board.
All right.
For Lower Township, New Jersey, I was just hired recently by Glenridge in an enforcement matter. I think that was by the municipal attorney in that matter.
Have you been accepted by the courts of the state of New Jersey and by any other courts as a noise expert?
Yes, yes, I have.
Okay. Do you have any publications in the field?
I've been extensively published in the field. As you can see from the resume that I have, in my resume, there's several pages of publications that I've
Now, just to be clear, is there any licensing available or required for an acoustical consultant?
not in the state of New Jersey.
Not in New Jersey, okay. I'd ask the board, if you have any questions, Mr. Zwirling?
What was his education? Where did you get your education from?
I have a bachelor's and master's degree in microbiology. I have a master's degree, I have a PhD, all but dissertated my PhD in environmental sciences at Rutgers University, meaning I finished the coursework, I finished the qualifying exams. I just did not submit the doctoral thesis.
Terry, do you have any questions?
No, I accept his
Well,
qualifications.
I guess my question is, what discipline
Right.
are you an expert in?
We are asking Mr. Zwirling to testify as an acoustical consultant and noise expert.
Okay, board accepts.
Board accepts. Thank you, Mr. Nance. And just to be clear, Eric, what were you asked to do by Mr. Parisi, and what in fact did you do?
I was asked to go out to his property and to evaluate the noise emissions that were coming from the Extreme Theater to determine whether they did in fact constitute a disturbance or not, to evaluate them both outside the property, outside the house as well as inside the house.
Now, just to be clear, you went out to Mr. Parisi's property on June 22nd till Friday, June 23rd, is that correct?
Yes, I conducted my measurements on a weeknight, Thursday, June 22nd, from about 11 p.m. Through till about 1 a.m. on Friday.
Now, in addition to going to the property, did you also review the transcripts of the April 13th and April 27th, 2015 hearing in front of this board?
Yes, I reviewed both of the relevant portions of both transcripts.
Did you review Howell Township's ordinances?
Yes, I have.
Did you review the report from the Monmouth County Health Department?
Yes, I did.
Did you review the appellate decision of State v. Clarksburg as to plain audibility, which was submitted as part of the overall package on June 14th?
Yes, I have.
Okay. Now, looking at sections 1.2 and 1.3 of your report, what did you observe and how did you measure it?
I arrived at about 11 o'clock at the facility. I went into the parking lot of the Escape Theater to see whether or not there was any noise coming from the parking lot area that might have been confused when I was at the residential property. There was nothing in the parking lot. I then drove around the backside of the building and could hear some rumbling from the backside of the building. I then went on to Mr. Parisi's property, somewhat close to the property line, maybe about 20 feet from the property line. If you'll, in my report on page, and I guess I apparently did not paginate this, and I apologize for
Page 5?
Yes, the site map.
Site map, I'm sorry.
Yeah, I'm sorry, the site map. The site map, if you have the report in front of you, there's a site map that shows I initially started my observations in the rear yard, which is within about 20 feet of the property line, with the Extreme Theater is on the other side, to the east, excuse me, to the west there. After taking some observations for a short period of time, I decided that it would be more appropriate to do my observations right at the building itself as well as inside the building. Because if you're looking for...
Which building, I'm sorry?
I apologize, Mr. Parisi's residence. If you're looking to determine whether or not there is a disturbance, it's most appropriate to make that determination at the location where the people are most reasonably to be disturbed. At 11 o'clock at night, it's not likely that he would be sitting at his property line, but rather maybe in the immediate vicinity of the pool, which is where the outside measurements were taken, and in fact also within his bedroom as well.
So you, just to be clear, you took measurements in Mr. Parisi's bedroom on the evening of June 22nd and 23rd, correct?
Yes, that is correct.
What equipment did you use for that?
I have a precision acoustical analyzer with laboratory certified. Field calibration checks were conducted as per the state noise code requirements.
Okay, and you took measurements using that, and when you took the measurements, are the measurements that you took inside Mr. Parisi's bedroom as shown on Table 1 on page 5 of your report?
Yes, those are the measurements inside the bedroom, yes.
And if you could summarize that for people who are not acoustical experts as to what does that mean?
Okay, measurements were taken both when the theater was on and when the theater was off. You want to make a comparison between source on and source off because that will then allow you to quantify just the source alone. If you look at the Table 1, if you look at the LC max, which is, the measurements are taken both on the A scale and on the C scale. C scale is much more sensitive to low frequency sound. That's what's used for the measurement of amplified music in many codes, in the model ordinance in the state specifically. And you'll see that at 1245 and 1252, I had a C-scale maxima of 57.1, 57.3, and then after the theater had closed for the night, the maximum level was 46.4. So there was a difference of approximately 11 decibels comparing when the music was on, excuse me, when the theater was on and when the theater was off.
Excuse me, so this is measured in decibels?
Yes, sir, they are, yes.
Okay, what, it's not a low-frequency number, correct? Or is this picking up the low frequency?
Yes, it is. So the two things that are the best at measuring the low frequency are either the C scale, should I explain the difference between the A scale and the C scale?
Yes, sir, you sure
Okay.
can.
Good, please.
Yes, okay. Many municipal ordinances are written dBA. The A scale is used because it essentially mimics human sensitivity to noises of moderate intensity and moderate frequency. It is specifically designed to discriminate against low frequency, because humans don't hear low intensity, low frequency very well. But you put low frequency through a subwoofer the size of a Toyota Corolla and a couple thousand watts behind it, and now all of a sudden you hear it very well. The C scale is much more sensitive to low frequency sound, and that's why the C scale is used in many jurisdictions for the regulation of amplified sound. Another measure of, so that's why that was used in this report. Another measure
Just to
is,
be clear, just so we're clear for the record, there's the A scale and there's a C scale, but both of them use decibels. It's how a decibel is then used, decibel on the A scale, decibel on the C scale, is that correct?
yes, I'm
Right. So when you use the word decibel, when we measure it, like when the county, as an example, when the county went out, they measured it on the A scale, is that correct?
yes, that's correct.
It's a decibel though.
Yes,
When you measured it on the C scale, it's still a decibel with a different scale of hearing, is that correct?
yes.
Okay, thank you.
Okay.
Please, if you could go on, Eric, and then describe what your chart on table 1 and on table 2 says. And just to be clear, how did you know the theater was off?
Well, 1 second, I think, Chairman, did you have another question?
Yeah, yes, I did.
I
I'm
apologize.
sorry, go ahead.
Are you familiar with the resolution? Did you read the resolution?
The resolutions, yes, I am.
Okay, based on that resolution, how does your report, how does that compare to what the resolution, as far as the applicant?
Well, if I could, to help you out with that question, on pages 1, 2, 3, you in fact go through the various transcripts of the hearing that took place in front of this board, of your report.
Yes,
And on pages 1, 2, and 3, you pick up and specifically reference the representations that were made by the applicant to this board.
yes, I do.
And as to the representations made by the applicant to this board on the meetings of April 13th and April 27th of 2015, are the statements of the applicant and its experts, which were the basis of this decision, accurate?
Excuse me, I object to the form of the question.
What's your objection?
Mr. Bagwell's not an expert. We did have an expert testify. Mr. Bagwell gave what his opinion was, but in that question, Mr. Jeva is indicating upon which the board made their decisions. And I don't know that's taking into more than the question.
Well,
that
Mr.
is-
Doty-
That Mrs. Whirling can answer.
Well, let me be clear. Let me just rephrase that. Because he's concerned that Mr. Bagwell is not the expert. In your report on pages 1, 2, and 3, you specifically referenced the statements made by the applicant's noise expert, Mr. Doty.
Yes,
And are the statements and representations made by Mr. Doty accurate?
no.
Why are they not accurate?
Both Mr. Dottie and Mr. Bagwell stated that there would be no noise present. They stated in their testimony that when they did their investigations at a theater, they were behind the theater and heard no noise whatsoever, that it was inaudible, that it was, all they could hear was traffic noise.
I have a
That's
question.
not-
I'm a-
That
I'm a-
wasn't my question.
I
My
understand.
question is the resolution.
Let me get to that. Did you also look at the resolution by this board at the last hearing and on the 15th, and specifically about all of the statements made by the applicant being representations?
No, sir.
Okay.
That's not my question.
Well, then
The resolution,
well, I would ask,
Mr. Kuchera, Do you have that resolution?
Yes.
The applicant's resolution. Could you please read the noise?
Sure. In paragraph 11, states, "Mr. Doty, an acoustical engineer, also testified at this hearing. He indicated that the walls of the proposed theater would be approximately 10.5 inches thick and designed to reduce any sounds from the theater. Based upon his studies at a similar theater located in Brick Township, he noted that at 80 feet from the theater during the showing of a film, the sound level was 45 dBA, and not all from the theater. He indicated that 50 dBA is nighttime, open paren 10 p.m. to 5 a.m., close paren maximum, and the 65 dBA, the daytime maximum for readings at the property line or occupied area. In this application, the building is approximately 190 feet from the property line. It was his overall opinion that the expected sound, if any, from the theater operation would be less than the traffic passing by on Route 9.
Okay. That's my question.
And if we could, just so you can answer Mr. Nance correctly, your
Excuse me, Mr.
report.
Chairman, can you just get in the mic?
So, so you can answer Mr. Nance fully and accurately. In fact, in your report, Mr. Doty, and the resolution says that he did a study, based upon a study, quote, "at a similar theater location in Brick Township." Is the theater in Brick Township similar to this theater?
No, it's not.
Well,
Why
I
isn't
just have to
If- if
interrupt
I-
here.
If I may.
No, first, because this goes directly to the relevance. We're not here to determine whether, the testimony that was given and the findings of fact were accurate or inaccurate. Our sole focus here is on whether the representations are being satisfied, whether their sworn testimony is in fact, whether the situation on the ground is compliant with their sworn testimony, not whether their testing was accurate or inaccurate, just whether what they swore, at this hearing is being complied with.
Well-
We can't go back and revisit, whether the board should have or should not have believed their testimony. They did. And now that's the law of the case here. And
I
we're just here to
understand.
see whether it's being satisfied.
Well, if I may, I guess two things. Thing number one, to go to Mr. Nance's question, did you look at the resolution? And is the resolution, are they complying with the resolution? But more importantly, it's what was testified in that resolution, what's set forth in the resolution. I just asked Mr. Zwerling a question. Is this a similar theater that
Well,
was
what
testified?
difference does it make whether it's a similar theater?
Then why don't I ask the expert that question?
Well,
What
fine.
difference does it make? What is the difference between the theater that Mr. Doty testified to and the theater that this is?
The two theaters are plainly not comparable because Mr. Doty stated that when he
Well,
was...
my question was, why is it relevant that they were different? Not whether they were different or not.
I would ask the expert to put on the record the basis for that, and then you can make a determination of relevancy. So if you could repeat yourself, what's the difference?
The theater that Mr. Doty was behind is not a theater that is an IMAX type theater with a sound system, the equivalent of the one at Dolby Atmos sound system as is at the Extreme Theater. And that's evident because when Mr. Doty did his analysis, he stated that when he was behind the building, he heard nothing. Behind this theater, not only is it audible behind the theater, it's audible 200 feet away from the theater, inside Mr. Parisi's house. So just on the face of that alone, there is no the comparability between that theater and the theater that Mr. Doty did his analysis at is lacking.
Right. Now, the last line of section 11 of the resolution says, in his overall opinion, the expected sound, if any, from the theater operation will be less than traffic passing by on Route 9. When you went out to Mr. Parisi's property, was the noise from the theater less than the traffic passing by on Route 9?
No, it was not. In fact, it was measurably more intense than that of the traffic. And that's specifically why you do what's called, in New Jersey, you take measurements of what's called neighborhood residual, and you take measurements of total sound. Total sound is the source plus the background. You take the neighborhood residual, the preferred method, actually the legally required method, is source off. So you wait until you stay in the same exact location, you wait till the source is off, whether it's a fan that's cycling on and off or something like that, or a theater on and off. And as you can see, on page, inside the bedroom, table 1 on page 5 of my report, when the theater was on, looking at the LC max column, 57.1, 57.3, 46.4 when it was off, an 11 decibel difference. Look at the next table outdoors. If you look at the, when the theater was on, LCF max, again measuring the C scale, it was 65 when it was on, 71.7 when it was on, 63.4 when it was on, and then 55.9 when it was off. So it was measurably, demonstrably, the difference between taking measurements at 1 o'clock and 1:34, there's no difference in the traffic on the road nearby. Had I
I
taken...
object to that statement. I don't know, unless you have some facts to back that up, by the way.
Well, I don't think he's finished his testimony,
I'm sorry.
so.
I didn't take my total measurements, let's say, during rush hour, and then take my source-off measurements when there was no, at 1 o'clock in the morning. That would clearly be inappropriate, because when the theater was on, you'd be including high levels of traffic as you would be at during rush hour. The difference between the traffic between 12:30, 1 o'clock, and 1:34, the traffic patterns are substantially the same.
Let me just be very clear and go to the heart of the resolution.
What-
The resolution, as Mr. Nansen has asked you, section 11, says, he indicated that 50 dBA is the nighttime maximum and 65 dBA the daytime maximum for readings at the property line.
Yes.
If you go to the property line, what in fact are the readings in excess of 50 dBc, or how you would measure dBA?
Well, if we're talking about the A-weighted levels, it is, the measurements that I took first, I did not take measurements at the property line,
Well, you indicated you took measurements outside of Mr. Parisi's
outside of
property.
Mr. Parisi's residence.
And are those
yes.
in excess of 50 at nighttime?
No, they're not. Not on the A scale, they're not.
On the C scale?
On the C scale, they are, but that's a different scale.
So when you looked at the transcripts of the hearing, was there any discussion at all about the C scale?
There was not. There was a discussion, the transcripts from the meeting stated that there would be no noise and that it would be quieter than the traffic.
Okay. So in the,
Both of those are not accurate.
both of those not accurate.
Hey, can I just ask
Go ahead.
a couple questions then?
Go ahead.
Because I think we're focusing a lot on what the testimony was at the hearing to whether there was a violation, and I think we have to look at, what the basis of the zoning decision was. So if I think I'm hearing correctly, you could tell me if I'm wrong, you're not disputing then that when the county went out using the A scale, that they didn't register any decibel level?
That's correct. We're not disputing that. We're not
But you're
disputing-
saying
we're
that-
not, just to be clear, so we're all using the same language, Ron, I apologize. I'm saying that when the county went out, they didn't find a violation of the county standards measuring the A scale.
Well, that's right, but if they found 0, they would have also necessarily found that it didn't violate paragraph 11. I mean, if you can't register any noise,
No,
then...
I think that's a leap, because when the county went out, they apply their standards, which is the DBA standards.
When you say their standard, I mean,
The county,
The state
Oh,
standards.
Jerry.
the county applied a set of standards. The standard the county applied is not the standards, and we're going to get into this, of Howell's noise ordinance. They're not the standards of the model noise ordinance, and they're not the standard that was utilized in the context of the application.
well, what you're saying...
Of the representations made to this board.
Well, I guess what I'm interested in then is where in the application process was it stated that you use the C scale rather than the A scale? What scale do you believe Mr. Doty was referencing when he talked about the various DBAs in paragraph 11?
I believe if you go to Mr. Doty's testimony in front of the board, as referenced in Mr. Zwirling's report, when he testified, he didn't testify specifically as to the A scale. He testified, quote, "Is there going to be any noise heard?" In fact, that was a question heard, and that's in
Yeah.
the point is this, Ron.
But on page 6 of your expert's report, it says, however, AAM Mills acoustic expert chose to report only A-weighted. Doesn't that say that they relied on the A scale?
Well, let me ask, AAM Mills chose to report only on his data.
No, it says report only A-weighted DBA data.
I understand what you're saying, but if you go to the testimony, we were asked to provide...
Well, that's the
specific-
conclusion of your
Yeah,
expert.
wait,
No, hear me out, hear me out. When you referred to on page 6, the data that Mr. Doty relied upon, was that the data in a report he provided, or was that the data, what he testified specifically on the record?
On the record, he testified specifically to the A-weighted measurements.
Okay. Now, do you also measure as to audible sounds?
He alluded to it, he stated that it would be inaudible, but he didn't submit in testimony or in written form data that would have been appropriate for low-frequency noise.
And in fact, didn't he have a colloquy with on the record, with my client, your client, and didn't he, Mr. Parisi, ask on page 95, lines 13 through 16 of the transcript, in response to Mr. Bagwell's testimony, that in fact there would be guaranteed that noise wouldn't be heard 150 or 200 feet from the exterior of the building? And didn't in fact, I think it was Mr. Bagwell then said, correct, it would not go that far. And then Mr. Doty on the 27th, when he was testifying, he also said that when he testified specifically about the noise, he said that it wasn't going to be any noise coming from the theater because there'd be more noise coming from traffic. So he referred to noise. Is that correct?
Yes. They were not talking in terms of regulatory compliance. And there's a very big difference between regulatory compliance and impact. They did not establish that the standard that they were going to meet. They didn't say, we are going to only meet the standards of the New Jersey State Noise Code. They stated that there would be no noise.
Right. And
There's a difference between
let
those
me
two.
just be clear on the record. On the transcript of April 27th, 2015, a member of the board, not my client, on page 54, lines 4 through 13, asks Mr. Doty as follows, quote, "So you can definitively guarantee to the neighbors that are here tonight on Castle Court and the other neighbors on Castle Court that the sound, coming from the theater won't affect," and I don't go further than that. Mr. Doty responds, "Well, I don't control the theater, I don't control the shopping center, so I can't guarantee anything. In my professional opinion," the board member asks, "in your professional opinion?" And Doty replies, "Based upon my 44 years of experience, what you just said." What did Mr. Doty testify to? Was he talking about plain audibility? Was he talking about DBAs at that point?
He said that there would be no noise.
And that was on the record.
Yeah.
And in fact, isn't that consistent with what is in the last sentence of paragraph 11 of the resolution that was adopted by this board?
Well, I mean, your expert, we're not qualifying him as an expert to tell us what Mr. Doty said. I mean, we
Well,
can determine what Mr. Doty
I
said.
understand that, but the point is this. Mr. Nansen asked me a question. Did he comply or didn't comply with paragraph 11? And it has to be based upon his testimony, and Mr. Zwirling has just indicated that, in fact, he doesn't comply. And that is one standard. If the board recollects,
But
at the last meeting, I was asked to provide objective standards, and we have 3 of them. So I'd ask for the opportunity to look at the other 2 standards.
Well, we're going to let you put on the case you want to put on, but before we leave, I want to make sure that everybody understands that, we're speaking apples to apples.
That is correct.
So, Mr. Zwirling, your testimony, based upon decibel levels, relies upon the C scale. The violation can only be found if you use the C scale.
What I was doing with the measurements that I took, both the measurements and the observations, was to determine whether it was audible, plainly audible, and also whether or not it was, and that was an observation,
All I'm asking
But also to quantify it.
is your conclusion based upon the C scale or the A scale?
on the C scale.
All right, because on the A scale, you would agree there's no measurable sound.
It is, I believe outside it is slightly higher. I'd have to look at my data again. It is not, I did not document a violation of the state noise code outside, but it is measurably higher outside than it was when
Well,
the
you said
source.
before that you didn't dispute that when the county went out, they weren't able to measure any sound or any decibel levels using the A scale.
No, first of all, it has been stated several times that they measured no sound, it was 0 decibels. That's physically impossible. What the county did when they came out, if recollection serves, that they measured somewhere in the low 40s dBA when they were outside. It's not 0 sound. What they measured was a sound level that was in compliance with the state code. I measured when the music was, when the facility was operating, somewhere in the neighborhood of 40 to 43 decibels. This is on table 2. Then, table 2, the first column, LAEQ, I have 41.2 when the theater was operating, 43 when it was operating, 40.9 when it was operating, and then 39.5 when it wasn't operating. So even on the A scale, I show that it was above the levels of the traffic. I don't show that it's a violation of the state noise code, but I do show that the levels are higher on the A scale than they were when the source was off.
And just to be clear for your testimony, about, like, wrap up this section and go on, as to the representations made by the applicant in front of this board about audible sounds, were they accurate?
No?
As to the representation made, that they've made a comparison between a movie theater in brick and what's here, what was built there, is that an appropriate comparison?
No, it's not.
Would a noise expert know that it's not an appropriate comparison?
He should have.
All right, you will also, for the board, we asked the expert to look at the model noise ordinance, which creates an objective standard. In fact, your report references the model ordinance promulgated by the DEP. Why is that relevant?
Excuse me, I would object to any discussion about the model ordinance because it does not affect Howell Township. There is a model ordinance, I'm aware of it, but it's not relevant to this discussion as to whether or not the land director would have been aware of that situation or even was capable of determining what it might be. And even if he did, it still would not affect this decision.
I believe at the last hearing, we were specifically asked to give a objective standard, not just a subjective one. And that's why we went out, and that's why we asked our expert, to provide an objective standard of noise so that this board had an opportunity to see whether, in fact, using an objective standard, not just I heard something, that in fact, whether it is or is not violated. I think it's very relevant to the direction that this board gave as to what this applicant has to prove in front of
I
this
think
board.
the board can give it its due weight, but I just want to go back to the county for a moment, because I think I actually misspoke, because it looked like the C scale was used also. It said, the caller complaining of noise from the Escape Theater, so they went to the site at 10 o'clock p.m. on Wednesday, 5/25. The winds were calm, the temperature was 76. The facility had 2 IMAX theaters. Caller states that the rumbling of the IMAX theaters can be heard in his house. Meter on A scale did not detect the change in noise. Tried the C scale, but it can only be used when the noise is a pure, steady tone. This was not the case.
Okay, and maybe on that day,
Well, isn't that what we're limited to, that day?
No, may I speak that? That's unfortunately a misinterpretation of both the state code and the model code. A pure tone applies, New Jersey regulates sound in 3 different ways: dBA, octave bands, which are measuring pure tones, and also measuring C scale. Octave bands may only be applied under the state code when the sound from the source is steady in nature, such as a mechanical device, a fan or a transformer. The C scale is used specifically when it's for amplified sound, for music. So unfortunately, the county, the investigator for the county misinterpreted that. The reason for that probably is that the county, the C scale only appears in the model ordinance. County people rarely enforce the model ordinance, so the investigator was unfamiliar with the methodology, and that's why that statement, which is a mistaken statement, was made.
So you, in fact, looked at the model ordinance, is that correct?
Yeah, I looked at the model ordinance. The reason why I used the model ordinance was that Howell's noise code talks about noise disturbance. There's a prohibition against noise disturbance. And what I wanted to be able to do was to quantify objectively the presence of a subjective nuisance. And one of the ways to do that is, in the model ordinance utilizes C-scale measured inside somebody's house to determine if there is an increase in the C-scale above the background level. And if it's 3 decibels above the background, the model ordinance states that that is objectionable enough that it considers that to be a violation. So in trying to prove, or to evaluate, I should say prove, because as a good scientist, I go out there just collecting data. I don't try to prove anything, I just collect the data, was to determine whether or not objectively I could determine whether there was a disturbance inside Mr. Parisi's house. I took the measurements on the C-scale so I could have a standard by which to compare it to.
And in doing so, and looking at the model ordinances, as Ron referenced, the county looked at, and you're looking at the measurements, what did you conclude in terms of whether in fact the noise there had violated the standards as established by the model ordinance?
The model ordinance, during the daytime, the permissible increase is 6 decibels on the C-scale. At nighttime, the permissible increase is 3 decibels above the ambient, the background on the C-scale. And on Table 1, if you look under the LC max, which is the maximum level, there is an 11 decibel increase. 3 decibels is that's the third column, LC max. The 3 decibel increase is what would be considered to be a violation of the model ordinance. There is an 11 decibel increase. So I believe that, I evaluated that I have objectively proven the presence of a level that would be considered disturbance.
So just to be clear, in looking at not just the representations made by the applicant in front of this board, but in fact the model ordinance, there was a violation of what would be the representations in terms of the model ordinance. Is that correct?
This would be a violation of the model ordinance.
Okay. Let me ask the last thing. I ask you to go to Howell's ordinances, because in the end, that's ultimately what the zoning official is asked to enforce. And so I would ask that you go to, oh, excuse me, it's embarrassing. Sorry about that. I would ask that you go to Howell's ordinance and specifically look at some of the definitions that are in Howell's ordinances. And the first thing I'd ask you to look at is, and in terms of Howell's ordinance, if you could go to section 208-1, which provides the intent and purpose, and if you could just summarize what 208-1 states and why it's important for this application. And first of all, what is section 208 in Howell's ordinance, and what does 208-1 state?
208-1 is the findings and purpose, which is the legislative intent that was passed by Howell in 1978. And it says that noise is excessive noise is a serious hazard to health and welfare and quality of life, that a substantial body of science exists by which to abate noise, that people have the right and should have an environment free of noise that jeopardizes their health and welfare, degrades their quality of life, and that it is the policy of Howell to prevent noise which may jeopardize the health or welfare of its citizens or degrade the quality of life.
Now, does that in any way stay only on the A scale?
It's a very broad statement.
So it doesn't say only if it's on the A scale, only if it's a steady tone. It talks about the impact upon health and welfare. Is that correct?
Yes.
Okay. If you could go to section 208-4, and for the record, read in how Howell describes a noise disturbance.
Oh, yes, this copy. Okay, I'm sorry. Any noise which annoys, disturbs, or perturbs reasonable persons with normal sensitivities, or any sound which injures or endangers the comfort, repose, health, hearing, peace, or safety of other persons.
Now, that's how Howell in section 208-4 defines a noise disturbance, correct?
Yes.
Does it use the A scale or the C scale as the definitional basis for that, or does it say any noise which annoys, disturbs, or perturbs?
As stated, there's no quantification involved.
Can you look at section 208-7A, general prohibitions, and reads what that indicates?
Noise is prohibited. General prohibitions: it shall be unlawful for any person to make or continue, or cause to be made or continued, or caused any excessive or unusually loud noise, or to create a noise disturbance within the limits of the Township of Howell.
So in the general prohibition of what's prohibited, it goes back to the definition of noise disturbance. Is that correct?
Yes,
Does it look at the A scale or the C scale? Does it just say noise disturbance?
it just simply states it prohibits a noise disturbance.
Thank you. And based upon your observations and measurements, are sounds coming from the theater a noise disturbance as defined by Howell's own ordinances?
Yes,
I object, again, that depends upon what noise there is as to whether or not it's objectionable. You're asking an opinion, I know what you're asking him. How
That's
would
what
you
he's
make
here
that
for, give us
determination?
his opinion.
With all due respect, he's an expert. An expert is entitled to give a net opinion. He's providing an opinion based upon...
Well, he's not entitled to give a net opinion.
Not that
He's
opinion.
not entitled to go as far as giving a net opinion, but in this case, he's actually taken measurements, he's read the resolution, he's read the transcripts.
I think the board can give it its due weight.
Thank you. In fact, if you could, one more time, just for the record, based upon your observations and measurements, are the sounds coming from the theater a noise disturbance as defined by Howell's own ordinances?
yes, I specifically did my observations on a weekday night, Thursday night, after midnight, when a resident, a working person would normally want to sleep. I did my observations within their bedroom, not at the property line, and after, well after midnight, the noise, the rumbling, it sounded like drums could be heard in his bedroom, and that to me would be a nuisance, a disturbance, and it was measurably, provably, measurably, not just by my ears, but by my data as well.
Right, and so for a zoning official to enforce this ordinance at the very base level, wouldn't he have to go out to the property?
To observe it, absolutely.
Now, your report references an appellate case identified as State v. Clarksburg. What's the relevance of that case?
That case discusses that a plainly audible standard in the state of New Jersey is a reasonable standard to be applying.
Okay.
Excuse me, is that all that he's going to say about Clarksburg as to what noise is?
Well, you're going to have an opportunity,
You have an opportunity to cross at that point.
Sonnenblick, to
Sonnenblick.
cross-examine.
Fine.
Right. In addition to the general prohibitions found in Section 208-7A, your report also references Section 208-7B2, A, and B. Tell me why that's relevant and whether, in fact, the noise as measured and observed violates those standards.
208B specifically prohibits the use of any 208B 2A, any sound reproduction device in essence, in such a manner as to create a noise disturbance. So it's operating or permitting the use or operation of any radio, receiving set, musical instrument, television, phonograph, drum, or other device with a production or reproduction of sound in such a manner as to cause noise disturbance, and B, operating such a device between 10 p.m. and 7 a.m. in a manner that it's plainly audible across a real property boundary or through partitions common to two parties, or plainly audible at 50 feet from such a device. Well, that motorboat, that's irrelevant.
Okay.
That's
So
the property line.
does in fact the noise as measured and as observed violate the prohibition as set forth in 208-72, B2, I'm sorry.
B2, yes.
All right. Now, I asked you to look at other sections of the ordinance, just so we can be complete, and so we're not seen as trying to not look at everything. I asked you to look at Section 208-7B9, which, when I first read it, said places of public entertainment. I thought that would be applicable, but what is that about?
That's about the sound levels inside the theater. That's a relationship between the patrons and the theater itself.
And so that, isn't there also a requirement here that they have to put up a requirement stating warning sound environment within may cause temporary hearing impairment?
Yes, that's what
So
that
that's
states.
really relevant to what goes on inside. I ask you to look at one other thing, and that is Section 208-11. And first, if you could summarize what 208-11 says and the maximum permissible continuous sound pressure levels, and in fact, just indicate whether that does, in fact, for the first time, reference DBA and what that says.
Yes, 2811 are the permissible sound level limits as measured, as you stated on the A scale.
And what does that say?
Well, the permissible limits in Howell's code are 65 dBA daytime, 55 nighttime at commercial, as receiving property, that's residential properties.
Right. Now, does that say that only these things are noise disturbances as defined by Howell?
No, it specifically states that noise disturbances are prohibited, and further goes on to specifically state what the applicable standards are for sound reproduction devices. Those are specifically called out and regulated separately.
Okay, so 20811 doesn't violate or doesn't void 2087, does it?
No, definitely not.
Okay. And just to be clear, based upon your observations and measurements, does the applicant meet the standards of section 208-7A and B2?
No, they do not.
A question. 20811, if you look at that, does this violate that under the decibels that they're speaking about? Under the Howell ordinance?
I didn't take measurements specifically for that, but I don't believe it does.
Right, and just to be clear, though, that's why we brought it up, that 20811 doesn't say that 208-7 doesn't apply, is that correct?
Many noise ordinances call out specific noise sources and regulate them separately. In this case here, sound reproduction devices are regulated separately, and the reason why that's done in many noise ordinances is because a sound production device is a volitional source. It is not an incidental noise, like with a tile saw, the noise coming off it is incidental. When you have a sound production device, you're choosing what volume to play it at, what time to play it at, the orientation of the speakers, all these, it is a purposeful act, and therefore, many jurisdictions regulate sound production devices separately and distinctly, as does Howell's code.
Okay. And just to be clear, is it your testimony, for the record, that the applicant violates the standards that they themselves testified to when they made representations of fact before this board in 2015?
They represented it would not be audible, and it is.
Is your testimony that, in fact, they don't meet the standard as set forth in the resolution, particularly as to audible sounds? That would be section 11, the last sentence of section 11 of the resolution.
It states that it would be less than the traffic noise. It is not, measurably not.
Is it your testimony that the applicant violates the standards as set forth, the specific objective standards as set forth in the NJDEP model noise ordinance?
It does not meet those standards.
Is it your testimony that the applicant violates Howell Township's own noise ordinance, which in fact the Clarksburg decision you indicate upheld?
Yes. I mean, excuse me, it does not meet the standards in the Howell's noise code.
One last question. Your report ends with an interesting comment. If you could elaborate on the comment you made as the last section of your report.
I just referred back to the findings and purpose of Howell's noise ordinance, where it states that specifically it is the necessity in the public interest, prohibitions, et cetera, safety, welfare, and the peace and quiet of the inhabitants of the Township of Howell. It specifically states that one of the goals is the peace and quiet of the inhabitants of the Township of Howell.
Your report ends with this sentence, and I'd like you to just elaborate on it. And it says, quote, Mr. Parisi and board members asked the right questions. The applicant and their experts gave the wrong answers. What do you mean by that?
Mr. Parisi repeatedly asked, will there be noises that are heard? He was assured that it was not. One of the board members, I believe it might have been Mr. Nansen, asked, is the theater that study that was done, did that have an IMAX theater in it? He was vaguely assured by the acoustical expert for the applicant that it was. It is not. They asked, the right questions were asked, but the answers that were given were not reliable.
I have no further questions of this witness. I would ask that the report, the transcripts, and the Clarksburg decision be entered into the record.
We already marked them into evidence. I have one.
But be accepted.
Yes.
Okay, thank you.
I have a question. And I'm not asking whether you agree with the conclusion or not. I'm just asking what you believe is meant by the sentence. And this is in the county's report, saying, meter on A scale did not detect a change in noise. What does that mean, a change in noise?
That the difference between when the traffic was running and when the investigator heard the thumping bass from the low frequency, the 31.5 hertz as I measured, that the A-weighted measurement did not move significantly enough to register. It is possible.
Well, I think that's what I was referring to before when I said they weren't able to register the noise. That what you're saying is when they took it on the A scale, and again, I'm not asking you to agree or disagree. You've already stated that you disagree. But what that sentence says is when they used the A scale, they didn't detect any noise above that which was coming from the highway.
Yeah, I didn't disagree with that. Yes, I agree that that's entirely possible, that those
Okay.
measurements taken on the A scale did not show a difference.
All right.
But that,
Well, that's all I wanted to know is what that, I wasn't sure what that sentence meant. So
Yes.
that,
I just wanted to correct that the statement was made that there was 0 decibels. That's, you know, as a scientist, that I had to state what was accurate.
I'm married to a PhD microbiologist. I understand the specificity. All right, so Mr. Gemma, before we move on, do you want to address the emails?
Well, I'd like to, does the board want to get my witnesses done and then give Mr. Sonneblick a chance to cross?
That's,
One at a time. Oh, can you,
We-
let me
we-
just
we
do the
can-
emails now and get it done with?
yeah, I think I prefer to just
Okay,
do
fine.
that. So what is the declaration against interest that you see in these emails?
The admission against interest in these emails are a fewfold. One, there are emails back and forth, basically indicating that they went out to the,
Well, I'm asking for the specific email, the date, and if you could direct me to the language.
there's the email that begins on June 1st
Mhm.
from Mr. Chansregan to Mr. Parisi.
Right.
The June 1st said, in that case, we've asked, since we received your comments, they checked the volumes, we were unable to measure any sound differences, and so in an effort to preempt any issues that may occur in the future, he instructed, Mr. Bagwell, instructed to lower the volume in the individual auditoriums, and I've asked our local theater manager to continue to.
Well, what is he admitting to? He's saying he didn't detect anything in
Right.
order to preempt anything in the future, he asked that.
That you're 100% correct. So when you read that one, they acknowledged they met with Mr. Parisi, and they had a colloquy with Mr. Parisi. Later on the July 13th email, Mr. Parisi responds back to them on July 13th, saying it's been nearly 1 month since they met at the property, so they could hear for themselves the theater noise that they've been complaining of. He wanted to know what steps they were taking in order to abate that noise. And on June 21st, Ziv Pinter, who Mr. Bruce will testify, says, yes, we are diligently working on this matter. We hope to have more information in the next few weeks. Thank you for your patience and understanding. And so the next set of emails you go to is on June 28th. On June 28th, Ziv Pinter again says, the sound engineer will be doing additional testing, and hopefully we'll have the results within the next few weeks. And then finally, Ziv Pinter responds back on July 13th, Mark, I just walked out of the theater. This is being worked on. I understand your frustration and appreciate your patience in this matter. There have been additional materials ordered. As soon as they come in, they will be installed. Please understand that everything takes time from the testing to come up with the right solution to the installation and the retesting, et cetera. And they tested it. I will be going on the road soon. However, we will try to get you a timeline as soon as possible. Certainly, these are emails from the applicant and from the manager of the theater that indicates they went out, and Mr. Parisi will testify, they heard something, they were going to do something, and they didn't. And that's all that it
Mr.
intended.
Sonneblick, you have a concise, brief objection to this?
My objection is that it is an attempt to ameliorate a situation. It is not an admission against interest. They didn't find that there was any noise other than the specific noise.
Well, do you have an objection to it being entered?
I
An
would
evidentiary objection?
Yes, I would object to the discussions between Mr. Pender and Mr. Parisi, because that was colloquy as to, in fact, I would state, and it
Well,
was
there's no colloquy exception
well,
in the
that
rules of
is
evidence.
true. I didn't think there was, but I thought it was
You're just
colloquy.
testing me.
Basically, it was simply that they were looking at it to see what they could do to lower the noise.
Well, that's not an
without-
objection. That's why you don't think it's relevant, you know.
It's not
that's-
relevant. It's not relevant to
That's
the
your
issue.
objection, that
Yes.
it shouldn't be entered because it's not relevant.
It's not relevant.
Mr. Chair, I would say that the board should enter it so that the applicant can have their record. However, in reviewing it, I don't find that there are any admissions in here. They said that they were trying to preempt a problem, but the board can give it its appropriate weight. I don't think it's, you know, prejudicial to enter it.
Thank you. I have no, then there's, as long as it's entered onto the record, Ron, then there's no reason to bring Mr. Parisi back up to just authenticate that, unless you want it authenticated. I have no further witnesses.
Mr. Sonnenblick, do you have any statement as to the authenticity of these documents?
No.
Okay.
Mr. Kuchera, at this moment, before we get into cross-examination, let's take about a 10-minute break.
Excellent. Okay.
Board recess 20 till 9. We'll reconvene at 8:55.
The zoning board will now reconvene.
Mr. Kuchera.
Okay, so, Mr. Gemma, do you have anything more for your affirmative case?
Other than summing it up at the end, I do not.
Okay, Mr. Sonnenblick, do you have any cross-examination you'd like to have?
Mrs. Whirling, the night of, you were there the evening of, I know it's 2 days, from 11 to 1, is that correct?
Yes, that's, yes. Mhm.
Right. And for how long did you, you said first you were by the building, first you were by the theater, then you were by the building, then you were, and by the building you meant the house, and then you were inside the house. And then you stayed till 1:30. How long a period of time were you taking these readings, each one of them that you took?
I took a series of measurements that were, I don't have the exact printout here, but they were generally in the range of about a minute to 3 minutes, something to that effect.
What was a minute to 3 minutes? I'm sorry, maybe I missed that.
When you're taking measurements with a logging sound level meter, you start and stop a sample. I mean, you could take a measurement that's, 2 hours long, but then you just have an unmanageable amount of data.
If you get a graph, is that what you're saying?
No, I'm just saying that if you turn the meter on and let it run for 2 hours, you have an unmanageable amount of data, and you don't have it representing individual events. So what I would do is when, for instance, when I would hear when I was in Mr. Parisi's house, and I would hear the sound from the theater, I would start the meter running.
You would hear a sound. You didn't know it was from the theater, did you?
Well, I could tell it was from the
How
theater.
how could you tell that? I mean, were you by the theater to know it was coming from the theater, or could it have been a motorcycle, or could it have been a diesel truck, or could it have been something else that created that sound at that time?
No. First of all, I've been doing investigations of this nature for 27 years. And I initially went out to the property line and near the theater, and was able to establish what the sounds, what the nature of the sound was like. So I could hear the rumbling nature of the sound. I then, outside the house, which was another, I think, 50, 75 foot further away from the theater, was able to hear, again, the characteristic nature of the sound emissions from the theater. Then when I went inside the house, and I heard the same characteristic emissions, I could tell that it was coming from the theater. And that's a common investigative tool, is that you fix your ear to the source by first going close to the source. You listen to either the frequency or the nature of the sound, and then you take measurements only when you hear that sound.
But if you were in the house and there was a noise and a motorcycle passed by on Lanesville, you know where Lanesville's Road is, by the way?
Yeah, right there.
Right, and did you get any noise from Lanesville's Road that you would be aware of?
There were noises that I excluded from my measurements. I specifically excluded extraneous noises.
And you didn't see that in your report that you excluded any extraneous noises?
Well, you just don't, if you're taking, for instance, if you're taking a measurement, and at one point, at think one of Mr. Parisi's children needed some attention, and I was taking a measurement. At that point, the child entered the room, I said something about it, and that measurement then was contaminated with an extraneous noise. I stopped the meter, reset it because that was a contaminated measurement, and then restarted again when the child was not there. And this New Jersey State Noise Code requires that you exclude extraneous noises, and that's exactly what I did.
In other words, people talking while you were taking the reading in the house, in other words.
I mean, if there was any sort of an extraneous noise,
Well,
either
and
from
that
outside.
would be somebody
Mr.
talking.
Sonnenblick, you asked a question, he's
Yeah,
trying to answer it.
Yeah, when you hear a noise that isn't, an extraneous noise is a noise that's not coming from the source, nor is it part of the steady neighborhood residual. And so it could be coming from within the house, it could be coming from outside the house. If I heard an extraneous noise, I would not take the measurement at that time.
So, in other words, for how long were you taking the measurements, these 1 to 3 minute measurements, during the course of your 2 hours that you testified you were in the area?
I took a series of these measurements.
Well, how many, approximately?
15, 20, I mean, I don't know. I don't know exactly how many. I mean, I could.
Would it be fair to say that you took 15 minutes at a time, or you said they 1 to 3 minutes is what you indicated to me?
Yes.
Is it 1 or is it 3 minutes? Or is it always just 1 to 3 minutes, and it doesn't matter?
Specifically, I was investigating the sound coming from the theater. When I heard the rumbling from the theater or the repetitive percussive noises coming from the theater, I would start the measurement.
And when would you turn it off?
When the sound stopped.
And by the way, what was the temperature that night, do you know?
I have the wind speed, but I do not have the temperature recorded.
Was it warm that night, by the way?
Again, the operational parameters of the noise meter is that if it's below, you may take measurements between 14 degrees Fahrenheit and 122 degrees Fahrenheit. It's not required that you report the temperature pursuant to the state noise code. But it is required that you report the wind speed, and that I did report.
And which direction was the wind going? Do you have that on there, too?
The wind speed was 0.0 to 0.7 miles per hour at 11:23, and 0.0 to 0.4 miles per hour at 1:07. So
It was moderate winds.
Objection, but
I mean, it's
don't
less,
specify the wind, just let them answer.
less than a mile per hour, I would
Well,
say.
okay, fine. One last question. When you're taking the testing within the house, in other words, you want to have the house fairly quiet, I would assume, not having extraneous noise when you're taking the testing, correct?
Well, I told the children to not, to not be moving around. I mean, at a certain point later on in the evening, they had gone to bed and they were asleep.
Was the air conditioning on?
I don't believe it was. I'm not certain. I mean, I didn't specify. Generally, when I come into a residence, I don't tell people. It's however I find it. I don't tell them to turn it on, to turn it off. It's however it is when I get there. I don't want to bias the collection of data.
No further questions.
That you're completed with your cross-examination?
Yes.
Okay.
Okay, Mr. Gemma, do you want a summation?
Please. Mr. Cucchiaro began tonight by reminding the board, and I agree with him 100%, that case law clearly holds representations made on the record bind the applicant. The representations made on the record in April of 2015 were clear. Our expert has testified, in fact, they were not met. Our expert has testified, in fact, that the language in the resolution that was adopted has not been met. Our expert has testified that it doesn't meet the model standard. And most importantly, our expert has testified that it doesn't meet the language as set forth in your own code. What we're asking for is relatively simple. We are asking this board to instruct your zoning official to go to the property, which he testified he did not do. And if he can find audible sounds consistent with this representation and with the record that was made, then to do what your ordinance says he should do. And that is pursuant to section 208-13, 14, and 15. He can apply fines, penalties, and seek to obtain an abatement. Further, we would like your expert, your Howell zoning official, to enforce the representations made to this board. And the way to enforce it is relatively straightforward. If you don't comply with a condition and a statement of fact to this board, then the applicant should not be allowed to proceed and get building permits, not get COs, until they comply. And that's all we're seeking. So we're just asking to make somebody who came to you, asked for permission to do something, live up to the standards that they themselves created. Thank you.
Mr. Chair?
If Mr. Sonelbeck is going to then try to sum after me, I would like the opportunity. Normally, the objector sums and then the applicant sums. So if he's going to say something, I'd like the opportunity to respond back.
I don't think Mr. Sonnenblick, do you have anything more to add? No.
Only once again, the model ordinance does not affect Howell. There is nothing that indicates that the noise is unreasonable, whatever may be heard, and I believe that the testing was done properly. And once again, I'm not going to comment, but when Mr. Parisi indicates that
I thought you weren't going to comment.
that well, I can't help myself. I have ADD somewhat. But basically, that in terms of the board would have the ability to do the various things that he just indicated in terms of what the shopping center has. There's nothing in my opinion, in the law that would permit that. No cases have been cited that they could do that. I understand that this is an enforcement case.
No cases, I don't understand what you just
No,
said.
there's no case that I have seen that would permit the board to talk about no further building permits for a shopping center and the like. I think there are things that you do in a situation like this, and in all the year that has been going on, and there was a time in which there was a reduction in noise, but basically, I think that you have.
That's not in the record, so I mean.
No, you have the right, he has the right to go ahead, make a complaint, indicate that we're in violation of any code, and we have to defend that case, and that's where he should be going, not
Well,
utilizing.
that's what we did. That's what he did. That's what we're
Yes,
here
he did.
for.
Okay.
Nothing further to add to that.
I wouldn't imagine you would, okay.
All right. Mr. Chairman,
Yes, sir.
so I need to address that, Mr. Sonnenblick's statements, because it goes to the heart of what any zoning board is permitted to do. So zoning boards are boards of limited jurisdiction. The municipal land use law tells us what we can do, what we can't do. Section 70A of the municipal land use law specifically provides that the board can hear and decide appeals where there is alleged by a appellant that there was an error in any order, requirement, decision, or refusal made by an administrative officer based or made in the the enforcement of the zoning ordinance. We have case law that says the enforcement of a resolution is the same as the enforcement of an ordinance. They're clearly in the right place. Whether they've made their burden of proof is a different story, but there's nothing improper about where they filed. They're in the right place. They could go different places. I mean, they could have easily filed a complaint with the municipal court, and we'll get to that. But the board has jurisdiction. This was a decision by the enforcer of the zoning ordinance that there was no violation. 70A allows an avenue of appeal to this body. So I don't agree in any sense of the word that somehow this matter should not have come here. But, I think we also have to look at what we are here for very specifically. And I know there was a lot of talk about the noise ordinance and state codes. We're not here for that. That's not codified within our zoning ordinance. It's not referenced in our resolution. If there are issues with violations of our ordinance or the state code, complaints can be filed in appropriate venues, whether they be the municipal court or elsewhere. What we're here solely to do is to determine whether the sworn representations made on the record concerning noise on this site in the resolution that we read from earlier, whether the applicant, or whether, Mr. Sonnenblick's client is satisfying that condition or they're in violation of that condition. And just to go to the end of it, to reread it, and this was Mr. Doty's testimony, was his overall opinion that the expected sound, if any, from the theater operation would be less than the traffic passing by on Route 9. So it's not that there's no noise, it's that the noise would be less than the traffic passing by on Route 9. So that's what we're here for, just that particular statement in paragraph 11. Has that been complied with, or has that not been complied with? So in reviewing whether it's been complied with or not, we have the report from the county health department, and it's not been disputed that when using the A scale, the county health department did not find that there was any increase in the existing noise from the highway. It's not disputed that the county also found that the conditions were not such that they could use the C scale. Now, testimony has been provided that the county was erroneous, not in the A scale, but in determining how and when it could use the C scale. So I think that's important for the board to note, that there's no dispute tonight that using the A scale, that the county's numbers were most likely correct, that there was no increase from the background noise from the highway. We haven't, I mean, the board can judge for itself based on the testimony whether something other than the A scale, is the method to be used here. But I think it's instructive that the report provided by the applicant's own sound expert or acoustics expert in this case acknowledges that AAM Mills was using the A scale when they made those representations. I think that's important because you have to take those representations in the context that they were made. And there doesn't seem to be a dispute that they were made in the context of the A scale. And I think when you look at the beginning of paragraph 11, when you look at the DBAs that were referenced, I don't think there's a dispute that those were in the A scale. So I think that's important in understanding whether the terms of paragraph 11 have been complied with, to understand the context of what it was talking about, whether it was A scale or C scale. So I think, we've heard a lot, but I think actually what you need to look at is very narrow. Again, it's whether paragraph 11, was the applicant compliant or not compliant? And in reaching that, you have to determine whether the zoning officer made the right decision or not. The zoning officer relied on the county. There's no dispute that under A scale, again, there was no increase in sound beyond that which was already present from the highway. And again, the representations made in paragraph 11, I think page 6 of the expert report seems to confirm that they were given in the context of an A scale. So certainly, I've tried to boil it down as simply as I can, but certainly if anybody has any questions, I can answer it and try to, make it clear.
You don't have any questions?
So if it comes down to simply that, is it more of a nuisance than highway noise? This gentleman said that it is in fact noisier than Route 9. Is that correct?
Yes. When measured appropriately.
Using the C scale.
Using this,
When
would it
measured,
matter a scale? I mean,
Yes.
Yes, it does.
are you asking me for, I don't,
can I ask him a question?
We've closed the public hearing, so, I mean, we can reopen it, if, Mr. Chairman, if you want. I think, it's really up to you as to whether you think it's relevant or
Well, you
not.
narrowed it down to if it's louder than the highway. And
Well,
I understood
on
this
the
gentleman to,
scale.
I understood this gentleman to say that it is.
What he said, I believe, is that if you take it on the A scale, it wouldn't register as being louder than the highway, but if you took it on the C scale, it would.
We're on the
Okay.
A scale.
That's clear as mud.
So in terms of, if there are no other questions, in terms of making a motion, I just want to make sure everybody understands what yeses and nos mean. So there are two motions essentially that can be made. The first motion would be to agree with the applicant and vote to reverse the decision of the zoning officer. The second would be to affirm, deny the application and affirm the decision of the zoning officer.
Okay. What's the pleasure of the board? You understand, the making of the motion? You're either affirming the land use officer that,
Okay.
using the basis of the Monmouth County Health Department, that there was no violation, or to overturn the zoning officer's determination. You confused or not?
So the deal is that if we make a motion now, that's for agreeing with,
Oh, sorry, I can't hear you.
You need to turn your mic on.
Speak into the mic.
oh, I'm sorry, I'm not turning it on first. What are we voting on right now?
To
What are we
either
making a resolution for?
the resolution to affirm the land use determination that they did not violate the resolution, or to confirm that the zoning officer was incorrect,
So,
that they did violate.
right, so you're saying the zoning officer was correct or incorrect?
That's
If you're
right.
saying the zoning officer was correct, it means that there was no violation of the terms of the resolution. If you're saying the zoning officer was incorrect, you find that there was a violation of the terms of the resolution.
Correct. Understand?
Yes,
Okay.
but you said something that there was two things.
Yes, those are the two. Either you
Okay.
agree or disagree.
It's not two separate items.
No.
No. There's two ways you could go on the same item.
Thank you.
Yeah.
Okay. What's the pleasure of the board?
Well, one more question.
Yes.
So we're basing the zoning officer's decision on using the A scale and what he got from the county as far as the report.
Well, the county actually had both. They said that on the A scale, they could not detect an increase in sound from what was there from the highway. They said that the conditions were not such that they could give a testing on the C scale.
What's the pleasure of the board?
Just a point of clarification, Ron. Which county report are you referring to? Because there were two. So if the board's going to do it upon the county report, they should have all the county reports there.
Well, I think it was the county report that Mr. Howard was relying upon, which was looking for the date. Oh, I think it's on here, the date. 5/25. Well, that was the date of the observation, was 5/25.
And what year?
The date closed was 5/26/2016,
So
and the
if-
observation was 5/25/2016.
So if there was a subsequent report by the county,
Do you have a subsequent report by the county you want us to consider?
I would believe there was, I think there was a subsequent report done sometime in May of this year. That's why I'm somewhat confused as to which county report. So if the board's
Well, we
gonna-
have an April 28th, 2017 memorandum from Monmouth County. It's not a report, but they reviewed their prior report. It says the department has previously validated a noise complaint, but has not previously validated a noise complaint, but if future complaints are received by this department, we will investigate.
So in fact, if they were, just so that when the board knows when they're voting, if the county was to have a report.
I don't want to deal in hypotheticals.
No,
If you have a
I'm just-
report you want us to look at, let's look at it.
Yeah.
Well, there was one dated May 10th. And I assume you don't have a copy of that?
Did you submit that?
I don't recollect, I don't think we did.
We only have what's in our
Okay.
records here.
Just want to make sure that I understood what what the board was voting on.
There's another one, August 3rd.
This is August 3rd, 2017, from Monmouth County Board of Health. Previous complaint received by this office could not be verified. Any future complaints concerning sound at this location will be investigated by this office.
Thank you.
So you think we're missing a report,
I think there was a report, but there's a subsequent report after that.
but
Yeah,
you didn't
August.
submit it?
Thank you.
Okay. Well, we have what's in the record.
Okay. What's the pleasure of the board?
Mr. Chairman, I'm going to vote affirmative on this, that the zoning board officer didn't make a mistake based on the A scale.
Have a motion to affirm zoning officer's decision. Do I have a second? Mr. Turk, you are eligible for this. Okay. Okay, I got a motion by Mr. O'Donnell to affirm zoning officer's determination, seconded by Mr. Turk. We have a roll call, please.
Mr. Amata?
No. Based on the fact that a noise is a noise, I don't care how you measure it. There's an old axiom about when a tree falls in the wood, does anybody, if they're not there, do they hear it or they don't? If you're there, you're going to hear something. Forget about the scale. The noise represents to this client a disturbance. And as I voted on other cases, when it comes to our citizens being disturbed by something that is really manufactured on a daily basis, I think that's not good for our citizens. So that's my opinion.
Mr. Cordelicchio?
Yes.
Mr. Mertens?
I'm going to vote no based on the same fact that Mr. Amato said, a noise is a noise. I did visit the site, and I don't fault our zoning officer because he's relying on a scale, but on a common sense scale. I heard the noise, and I'm voting no.
Mr. O'Donnell?
Yes.
Mr. Posh?
No.
Mr. Turk?
Yes.
Chairman Nansen?
Yes.
Motion carries.
Thank you.
Thank you.
Thank you.
Okay. Is there any further business of the board?
No, Mr. Chairman.
Mr. Mallon, Mika?
No, sir.
Okay. Okay, can I have a motion to adjourn?
I'll make a motion to adjourn.
Second.
Motion by Mr. Amata, seconded by Mr. O'Donnell. All in favor?
Aye.
All opposed? Zoning board adjourned at 9:25.